Okay, we're going to start with special education. Melanie, would you like to start and give any comments you have about your rule and what to look at?
Sure, I'm Melanie Reese, District Resolution Coordinator, and we have three things going up before the rules. We have the incorporated by reference. So the Idaho Special Education Manual, there was an oversight that we were not incorporated by reference in the Idaho, or in IDAPA, and so to address that oversight, we're adding the rule to IDAPA that says that the Special Education Manual is part of the rule, so that there's some enforcement to it. Additionally, with the passage of ESSA, there is the change to the highly qualified teacher requirements, so we will be addressing that rule. I don't have language at this point on what that rule will look like, but, pardon me?
I was going to say, sorry, not yet.
Not yet. It's something that we are saying it's going to be done at some point, but it's still pretty new for us in terms of what that's going to look like, but we will be in alignment with Superintendent Ibarra's most recent memo about the changes to highly qualified teacher. The next two items, one has to do with the 10-day rule for students who are on IEPs. So a student, back in the year 2000, prior to the passage of IDEA, Idaho was one of a handful of states, and now the only state that has what's called a 10-day rule that allows for a parent to, or parent or adult student to challenge an IEP proposed by a district, and it puts it into what's called stay put until it's resolved. If it is not resolved, the way in which the rule currently reads, the school district, if they want to enact the IEP, must engage in a due process hearing in order to push that through. This, the IDEA was passed in 2004, and since then we've had a Supreme Court ruling that has addressed due process hearings and burden of proof. And the current IDAPA rule is not in alignment with that those changes. So what the new 10-day rule proposed would be that parents could still challenge within 10 days an IEP. It would go into a 15-day resolution time, whereas whereby the district and the parent could engage in mediation, continued meetings, facilitated IEPs. They could work together if they wanted to extend that 15 days, but if the 15 days comes and the parties have not agreed to extend it, then the IEP will be enacted as written, and it will be the parent's responsibility to file a due process hearing instead of where it was the district's responsibility to file a due process hearing, which is in alignment with IDEA and the Supreme Court ruling by Schaefer and Weiss. The last rule change that we have has to do with mediation. The current IDAPA rule requires that before a mediation can be done, that all parties need to sign a confidentiality agreement. Recent guidance from the Office of Special Education Programs, our oversight, federal oversight group, has indicated that we can no longer require a signed confidentiality agreement as a precursor to engaging in mediation. So therefore, our IDAPA rule needs to be changed to read, we will provide notification of expectations of confidentiality, no signatures required, just letting them know that's the expectation. IDEA, the Individuals with Disabilities Education Act, already addresses the limits of disclosure, so it really was a formality that isn't necessary. So those are the changes that are going in for special education, along with just some typographical changes in the manual.
Thank you, Melanie. We have one person that is signed up to testify. We have Rose Larson.
So, hi, Melanie. Rose Larson from Snake River School District in Blackfoot, and I'm the special ed director there. So my questions were a little bit about highly qualified and what's happening with highly qualified for our teachers in special education. And then the other piece was just, I like the clarification that you had on the 10-day to the 15-day. So I just want to make sure that I understand that. So we have 10 days for the parents to say yay or nay whether they're happy with an IEP. If they're not happy, then we have an additional 15 days that we go back and forth, can mediation to try to resolve the situation. If it's not resolved at the end of the 15, then the IEP is enacted the way we did it, the way it was prepared. And then the parents, it's up to them to file, if they want to file a due process. Is that my understanding?
That is correct. Oh, I'm so late. Till the runner comes. I could walk over there. I'm not afraid of Rose. You are correct. Once a due process hearing is filed by the parent, it goes into what's called stay put. So the old IEP would be enacted. So it really doesn't change much in terms of protections for parents. If they don't agree with the proposed change by the district, by filing a due process hearing, that change cannot be implemented. It goes back to stay put. But it just changes on who has to file. Again, it's in alignment with IDEA and the Schaefer versus Weiss decision for the Supreme Court.
So the other piece then becomes the highly qualified teacher piece. And do we have any kind of a timeline that we're going to have some resolution? I had spoken to one of the gentlemen or actually the person that was involved with highly qualified at the State Department, and she had said I talked to her about 2 weeks ago, and she said that they thought they would have language by now. So my wondering is, do we know what that's going to look like? Because I have teachers that significantly impacts, and we really need to be figuring that out. Sorry, I moved over by Melanie.
It's okay. It's a good idea to keep our distance. So the change to the highly qualified teacher, the information that we got was on April 7th of this month. It was the letter that was sent out by Superintendent Ibarra, and that was really the first information that we had in terms of there were going to be changes. And I am probably not the best person to speak to this, but my understanding is that with ESSA, states were required to come up with their own parameters for what highly qualified teacher would mean. And this is the first step, this memo that went out from Superintendent Ibarra on what that looked like. What that means specifically for special education beyond what she has written, we haven't gotten that far yet. I can tell you, Rose, that I'm going to be going to the LRP conference in New Orleans next week, and I'm meeting with Art Sernozia, and we are going to be talking about what this might. He's our legal consultant for helping us in drafting language, and I'm going to be meeting with him to talk about that. I don't have an answer for you yet, but I know that one is coming, and I also know that Director Silva is looking to have Art Sernozia do a webinar based on the changes of ESSA and what it means for Idaho. So all I can tell you is something's coming. I don't know exactly what it is, and I don't know who would.
Okay.
But something's coming.
Thank you.
Something good.
Are there any other questions about the special education revisions? Okay.